Leave it for correction first. So writ petitions have been allowed to the extent that the orders have been set aside. They are to be reinstated with liberty to proceed. But only rider is if under the contract, if they want to discharge, then that will be an independent action. That will not come in the way. You can see the judgment little
Yes.
later when there is some correction.
Did operate.
This motion matter may be listed after tomorrow.
What is it?
After tomorrow matter may be listed.
What is the
Motion-
matter?
for Motion, compulsory table.
Yes.
My lord, this matter may come up, item number 17, my lord.
Ah,
This matter may come up after vacation, my lord.
on the request of Ms. S.B. Chaudhary, Learned Counsel for the writ petitioner, this letter stands adjourned, list again after the summer vacation.
May I please your lordship, I beg to mention one
Huh?
for impediment. I have already filed on 27th of June, my lord.
It has not been listed. 27th of June.
Yes, I have filed on 10th,
27th of June is yet to come.
then 26th, my lord.
Acha, 26th. When did you file it?
10th of June.
It has not been listed.
No, my lord.
All right.
Worship, I am praying for listing of a fresh writ petition, my lord. Grievances against the health department. It was filed in 17th itself, my lord, but it has not come up. May I pray for tomorrow's listing?
Yeah, please,
Okay.
Your Lordship, I pray for listing of a writ petition. The matter is the petitioner
Listing for what?
listing of matter in motion stage. The matter is the urgency is that the petitioner was asked to vacate his married accommodation. So as such, there is some urgency in this matter.
Accommodation.
Married accommodation, because petitioner was transferred from Tezpur, which is a static zone where there is accommodation to Arunachal Pradesh, where it is non-static zone.
All right.
Your lordship, praying for listing of one matter which has been recast by your lordship, you can add, the Honorable Justice, you can add yesterday. So any date,
Listing for what?
listing for, it's a content matter, lordship.
Hmm.
The incumbents, new incumbents were implemented, only the notice is to go. Pensionary benefit,
Day after tomorrow.
deeply obliged.
Well, item number 10 for motion. Annexer has been wrongly annexed, my lord. Document pertaining to some other candidate has been brought on record.
Acha.
So I have to withdraw it and file replacement.
You want to withdraw?
Item number 10.
All right. Mr. J. Patwari, Learned Counsel for the petitioner, submits that there is some defect in constitution of the writ petition. And therefore, the petitioner be granted leave to withdraw the writ petition with liberty to file afresh. Since the prayer is not opposed by the respondent's counsel, same stands allowed. Writ petition stands disposed of on withdrawal with liberty as prayer.
Deeply obliged.
Yes.
Please, Your Lordship, I'd like to mention listing of a writ petition, Lordship, relating to non-payment of pension. It may be listed tomorrow, Lordship.
It is a motion,
Yes, sir.
motion matter. Day after tomorrow.
Much obliged.
My lord, this petition is filed for non-compliance of the order dated 24.
I heard Mrs. N.S. Thakurial and counsel for the petitioner. There is the statements made in the contempt petition alleging willful disobedience of the directions contained in the order dated 24/2/2025, passed by this court in WPC number 303/2025. This contempt case has been filed. Issue notice returnable in 8 weeks. Petitioner to take steps for service of notice upon the response.
Yes, yes.
May it please your lordship. My lord, your lordship may kindly see page 104.
My lord, the affidavit, my lord, can it be after some time, my lord? We are filing it today, my lord, after some.
My lord, I'm giving a hard copy. Your lordship will just kindly just see page 104. There is a procedure prescribed for appointment on compassionate ground, and particularly at page 110. 110 clause clause 9, the compassionate appointment has to be filled up within 6 months. And
Mr.
clause
Das,
12.
what
Yes.
order are you expecting today? The writ petition will be allowed.
I
It will not be
book a
allowed.
second.
So let the affidavit come on record
Yeah.
and then you examine it. And their ground is that no SIU
Yes.
approval was obtained.
Prior-
See, it
have
is not necessary. It is not necessary.
That is
because
your
of the-
opinion, but the
Mine.
court will have to give its view.
Yes, I'll have
You are entitled to make your submission.
yes.
Whether that is correct or not, that will require a determination by the court. So it cannot be done without the affidavit being
My
on.
lord, that is all right. My lord, your lordship will kindly see this man was appointed in the year 2017. He got salary for a period of 3 months. He is
Hmm.
continuing. He is a jarikar. And his appointment is by chief secretary, finance secretary, and a committee of high powered body. That's
Mr.
your
Das, I
lordship.
am asking you, what is the order you are seeking right now?
My lord, he should
Again,
not
I
be
will
out.
give, otherwise.
No, he should not be outset and his current salary should be paid back. He should survive, my lord.
No,
He
are
should
you,
survive, my
are
lord.
you planning to terminate him?
No, my lord, no such apprehension, my lord, as on date at least.
No, but they have refused that.
Just a minute, just a minute. Where is the apprehension? Which paragraph?
Yes.
My lord, page 72, they have rejected my.
No, no, in the
Page
writ petition,
71.
which paragraph is the pleading regarding apprehension of termination?
Well, I'll see that. Page paragraph 14, man.
14.
Page 19.
So you file your affidavit, we'll put it after vacation.
Lordship.
You'll not terminate without
Of course,
leave
my
of the
lord.
court.
And current salaries, my lord, your lordship will kindly.
That may be
see.
considered.
Why I'm saying, your lordship will kindly see page 1110, 110. There is a reason behind, because they have mixed up everything. 1110 and clause 12, your lordship will kindly see.
All right. Heard Mr. B.D. Das, learned senior counsel appearing for the writ petitioner. Also heard Mr. B. Gogoi, learned additional AG, bracket finance, Assam, appearing for the respondents. The writ petitioner herein was appointed on compassionate ground as a Jari Karak, bracket process server in the establishment of respondent number 5 on compassionate ground way back in the year 2017. Full stop. The appointment of the petitioner was pursuant to recommendation made by the state level committee, bracket SLC. Full stop. After rendering service for a few years, the respondents have now stopped the salary of the petitioner, allegedly on the ground that the appointment was not made with the approval of the finance, bracket SIU. Full stop. Apart from assailing such decision of the finance department, the petitioner has also expressed apprehension that his services may be terminated on the same ground. Full stop. Mr. Das, learned senior counsel appearing for the petitioner, has highlighted the extreme hardship, faced by his client and has prayed for an interim order directing the respondent to release his current salary.
That will be difficult. Let the finally decide.
Mr. Gogoi, learned additional AG Assam, submits that an affidavit on behalf of the department will be brought on record during the course of the day. Till such time, no further order be passed in the present proceeding.
Right.
After hearing the submissions made by learned counsel for both the sides, this court is of the opinion that the matter would require some consideration. As such issue, notice of motion returnable on 18th of July 2025. Since Mr. Gogoi has appeared for all the respondents, no formal notice, no, not all the respondents. Mr. Gogoi has appeared for the respondent numbers,
I can appear for all, man.
all the respondents. No formal notice is required to be sent in this case. Extra copies of the writ petition requisite in numbers be furnished to the Learned counsel for the respondents, if not already done, full stop. A counter affidavit on behalf of the respondents be brought on record, be positively brought on record during the course of this week by furnishing advance copy upon the petitioner's counsel. Mr. Das, you are being assisted by whom?
Mrs. Decca, my lord.
Achha,
Runchi
then
Decca.
assisted by Miss A. Deca.
I Decca.
I.
R.
Deca. Hard on the prayer of interim relief for release of current salary of the petitioner. The said prayer will be considered on the returnable date. The respondents counsel to come prepared accordingly. However, as an ad interim measure, it is hereby provided that the petitioner's service shall not be terminated without the leave of the court. Full stop. It is further provided that pendency of this writ petition shall not be a bar for the respondents to release the current salary of the petitioner, if so advised.
Obliged.
Obliged.
Yeah. Put to challenge your lordship, this disciplinary proceeding, your lordship, initiated your lordship, filed a search memo, your lordship, at page 30, your lordship. Your lordship will get it, and two grounds we have taken, your lordship. One is, your lordship, this has the genesis in a FIR, your lordship, a criminal proceeding initiated against him, which has, your lordship, been presently
No, just a minute.
lost.
What is the relief you are seeking here?
I am seeking, your lordship, the proceeding, disciplinary proceeding is, your lordship, till completion of the criminal proceeding, your lordship, disciplinary proceeding may be stayed, your lordship. That's the prayer, essentially prayer we have made, your lordship. And your lordship, the ground, your lordship, if your lordship comes to page 30, your lordship, this is the chart sheet, your lordship.
Page 30.
Page 30, your lordship. Charge 1, your lordship. That while you were working as an inspector of taxes at Kukurajar unit, you were caught red-handed on 29/6/2017 while taking bribe of ₹1 lakh from the complainant so and so. Assam and proprietor Mrs. Prosenjit Electronics are subsequently arrested in a case registered with Directorate of Vigilance and Anti-Corruption Assam under section so and so. 7-13-1-13-2 of the PC Act 88, section 120B of the IPC read with section 7/13-1D-13-2 of the Prevention of Corruption 1980 for demanding and taking gratifications other than that their legal remuneration in respect of an official work by adopting corrupt and illegal means and also abusing your official position as a public servant holding the office of the pecuniary advantage. The case is presently under trial. Then you are therefore charged with lack of integrity, breach of trust, serious misconduct and action. Then second charge, your lordship will see that from the steps of investigation, analysis of the facts and circumstances emerging during the course of investigation, the allegation of the FIR submitted by the complainant against you was found well established. The demand of the bribe by the accused and the receipt of bribe gratification from the complainant have been established beyond any doubt. They have already given a finding, your lordship.
Now, you have submitted your written statement.
I have submitted my preliminary written statement asking them a copy of one of the documents, your lordship, which has not been furnished to me, your lordship. Without furnishing that, your lordship, they have started the process of hearing, and I was asked to appear tomorrow, your lordship. Tomorrow is the date of hearing fixed, your lordship. At that stage, your lordship, I am before this honorable court on two grounds, your lordship. Non-furnishing of a copy, your lordship, of the document they have relied on, and secondly, your lordship, in continuation of the criminal proceeding on the same set of evidences, same set of facts, your lordship, and the FIR is the basis of the both criminal proceeding and disciplinary proceeding, your lordship. Therefore, your lordship, if I am allowed to participate in the disciplinary proceeding, your lordship, and I disclose my defense, it will prejudice me in the criminal proceeding, your lordship. That's the ground, your lordship, I have taken, your lordship. And then as far as your lordship law is concerned, your lordship, well aware about the Paul Anthony and others, your lordship.
Paul
That I
Anthony
have,
is-
my lord, yes. But here, my lord,
No, let him,
first of
why
all,
don't you let him finish?
Lords. That's Paul Anthony and one more judgment of our High Court, your lordship. para 22 of Paul Anthony, your lordship. After analyzing the earlier judgments, your lordship, the conclusions which are deducible from various decisions of the courts referred above, departmental proceedings in a criminal case can proceed simultaneously, and there is no bar in being conducted simultaneously, though separately. Then two, if the departmental proceeding and criminal cases are based on identical and similar set of facts, and the charge in the criminal case against the delinquent employees of grave nature which involves complicated question of law and fact, it would be desirable to stay the departmental proceeding till the conclusion of the criminal proceeding, your lordship. And your lordship will kindly take up the other judgment division bench of our high court, your lordship. I have given your lordship. It is
The division bench says if the person is acquitted in the criminal case,
lordship.
there cannot be departmental proceeding.
One case, your lordship, there is a case, your lordship, where GM Tonk, your lordship, with honorable acquittal is there cannot be, there should not be disciplinary proceeding. Your lordship has relied on their judgment and passed an interim order in one case, your lordship, that in the division bench judgment, your lordship, just now I have handed over, your lordship will find para 30.
There are 30.
30. It has relied on Paul Anthony, then para 29 and GM Tank also, your lordship, then 30, your lordship will see. However, so far as the second charge is concerned, this court has observed that concerned criminal case is still at the trial stage. Under those circumstances, it has to be examined as to whether the correct approach was adopted to go ahead with the disciplinary proceeding, since the charge is same both in the second criminal case and charge number 2 in the so-called notice. It was not proper on the part of the disciplinary authority to go ahead with the second charge, as the same would amount to exposing the defense of the writ petitioner in the criminal case. And ultimately, your lordship, that part of the proceeding, your lordship, relating to the second charge, which has directly related to the criminal case, your lordship, was directed to be kept in abeyance.
Where is the charge in the criminal case?
My lord, that has not been submitted. I was supposed to make that submission, my lord. They will have to substantiate that with a charge sheet, my lord. That charge sheet has been submitted, he is accused there. These are the set of witnesses or evidences which are similar to the, my lord, departmental proceeding. That has not been annexed, my lord, not even the summon. Only a statement, my lord, in the petition. At least to satisfy the court, that will have to be placed.
In fact, your lordship, charge number 2 itself reflects everything, your lordship.
Investigation is different thing, my lord.
Oh, it is a
FIR is different thing.
and there is a categorical finding that it is under trial.
No, just a minute. I'm trying. What is this?
My lord, yes, my lord, the other ground is that, my lord, page 35 in the list of documents.
No, this is a letter dated 23rd of June 2000 addressed to you.
Yes, my lord. Here, lordship will see the, my lord, next page. There is an enclosure. A letter dated 16th of October 2023. This was a document which was supposed to be furnished to the petitioner. And for non-furnishing of this document, petitioner has stated that he has not been able to submit an effective reply to the charge memo. So here, my lord, on the last occasion, Honorable Court has said that I will furnish it to the petitioner before the court itself. Now, my lord, there is one error in the charge memo in the list of documents that, my lord, this date 16th of October 2023 has been wrongly typed as 16/8/2023. So that, my lord, was clarified to the petitioner, and in fact, this copy was submitted. That's the instruction I have got from the.
So it is actually
even then,
16/10/23.
I will furnish it today itself to the petitioner.
There is no document of 16/8/2023.
Yes, madam. In fact, the other issue numbers are same. So this is the document. we are relying on.
All right, Mr. Botakur, the larger issue,
Lordship.
which you may have a point,
Lordship.
but then you have to show what is the
Yes.
charge.
Lord.
You can't say that it is same, but I'm not showing.
No,
what is it.
no, that I will not say, Your Lordship. But
Then-
the point is, Your Lordship, why I have not, Your Lordship, annexed, Your Lordship. I can annex, Your Lordship. That since the charge sheet itself reflects everything, Your Lordship. FIR, that it is under trial, Your Lordship. The genesis of the case, Your Lordship. Everything has disclosed by the charge sheet itself, second charge, Your Lordship.
So you are saying that because
No.
of that, there can be no proceeding
no.
against your client.
That is what I am submitting, Your Lordship, since the finding, the charge sheet itself says, Your Lordship, that the basis of the allegation is an FIR and criminal case is going on, the investigation made therein, and Your Lordship kindly see the word they have used, beyond doubt, Your Lordship. They have already, in fact, arrived at a conclusion that everything has been proved beyond doubt, Your Lordship. After, Your Lordship, arriving at that conclusion based on the
I have
investigation.
Understood, but now please tell me one thing.
Lords,
These grievances can be clarified in half a second.
Lords.
We can only say that these observations made in the charge sheet will not be given any weightage during proceeding. If you want that, that can be
No,
done.
that is not my case.
But substantively, your ground is that this is a case where a departmental proceeding and a criminal proceeding is going on the same set of allegations, same charge. If that is correct, then you may have a case of
Lords.
interference. But then where is what is the charge in the criminal case?
Lordship, that I will bring by way of an additional affidavit. Okay. That I will bring by way of an additional affidavit, Your Lordship.
How much time you want for that?
Your Lordship, within week, Your Lordship, vacation is coming, therefore, Your Lordship, immediately on the date of reopening, Your Lordship, in the meantime, I will file the additional affidavit.
All right, then we'll give him exemption from appearance tomorrow.
Yes.
Lords.
Or let him apply, my lord, at least, he can seek the adjournment tomorrow, my lord, by way of application that matter is pending, it will be listed on so and so. I will
But he
intimate the
submit
authorities.
it,
Yes, he can
we'll
submit
give
an
us
application.
exemption,
Lords.
but he will submit an application intimating about this
Yes.
order.
That's intimating the authority.
Yes. All right, then we'll have it for motion on 16th of July.
Lords.
Lordship.
16th of July.
Lords.
In the meantime, you can give him a copy of the document
Yes. ma'am.
dated 16/10,
Lord,
2020.
ma'am, that today itself I am punishing.
Lord.
All right, you take down. Heard Mr. S. Bhattakur, learned counsel appearing for the writ petitioner who submits that this is a case where the authorities are proceeding against the petitioner simultaneously in a criminal case as well as departmental proceeding based on same set of charges which are sought to be established by relying on the same sort of documents and witnesses. Witnesses in a manner which is impermissible in the eyes of law. Full stop. It is also the submission of the petitioner's counsel that the department has failed to furnish a copy of the document dated 16/8/2023 relied upon by the authorities during the departmental proceeding. Full stop. Contending that the departmental proceeding, contending that the date of appearance of the petitioner in the departmental proceeding is fixed tomorrow, that is, give the date 25/6/2025. The petitioner's counsel has prayed for an interim relief. Full stop. Responding to the above, Mr. B. Gogoi, learned additional AG, Government of Assam, has submitted that the correct date of the document is not 16/8/2023, but 16/10/2023. And he has handed over a copy of the said document to the petitioner's counsel during the course of this proceeding. Full stop. Mr. Gogoi has also pointed out that there is no material on record to indicate what is the charge framed against the petitioner in the criminal proceeding. Full stop. Responding proceeding. Mr. Bhattakur has, however, sought a week's time to file an additional affidavit bringing the charge framed in the criminal proceeding in the record of this case. First, a prayer aloud. On the request of the petitioner's counsel, let this matter be listed for motion again on 16/7/2025 as a fixed item. Considering the fact that the date of appearance of the petitioner in the departmental proceeding has been fixed tomorrow, he is hereby granted exemption from appearing before the inquiry officer till the next date fixed, that is 16/7/2025. The petitioner is however directed to submit an application enclosing a copy of this order before the enquiry officer tomorrow, that is on 25/6/2025.
Obligement.
Mr. Bhattakur, you can take back this for now.
Lots.
The next
Take
date.
that one.
This is for go with, yeah. Yes.
May please,
Yes.
Lordship matter relates to the promotion of the petitioner to the post of assistant engineer, Lordship.
Mm-hmm.
Matter relates to the promotion of the petitioner, the post of assistant engineer.
Will issue notice at this stage? Notice?
That can be done, my lord, but his prayer is direct for promotion, my lord. But it is admitted, my lord, that one criminal case is already pending against him.
So you obtain instruction
yes.
and find it.
Yes.
Pardon, Mr. M.K. Boral and counsel for the petitioner, that is the statements made in the writ petition. The relief prayed for by the petitioner is for issuance of a writ of mandamus directing the respondents to consider his case for promotion to the post of assistant engineer in the Panchayat and Rural Development Department. Full stop. Mr. S. Dattal, and a standing counsel for the PNRD department, has prayed for some time to obtain instruction. Prayer allowed, issue notice of motion returnable in 6 weeks. You are appearing for all the
All
respondents.
the respondents.
Since Mr. Datta has appeared and accepted notice for all the respondents, no formal notice, extra copies.
I love this.
With the lordship. The petitioner is presently working as section assistant minor under executive engineer in the Masa district. The initial appointment approval was at the lordship, may kindly see annexure on page 32, my lord.
Yes.
I have the honor to inform you that there is 3 numbers of section and the post are lying vacant after this, and 5 numbers of section essay, section assistant post also vacant due to retirement of SS who are transferred from. So at that time, my lord, page 32 on 11 August 23, some post, the 5 posts were vacant. Therefore, my lord, that in connection, I am to request your honor that the case of Sri so-and-so, son of so-and-so, the retirement month of February may kindly be considered on humanitarian ground. Matter may kindly be approached to the district council for approval. This is for your. Thereafter, my lord, page 33, government has accorded the approval. I think refer to cited above. I am directed to convey the government approval to the appointment of Sri so-and-so essay on ad hoc basis for a period of 6 months or till regulation as per provision of rules and procedure in force, whichever is earlier with effect from the date of entertainment under North NC Hills Division. Qualified. After my lord, his appointment is at my lord. Page 35. In persons of Secretary, Executive Committee, Autonomous District Council, Haflong, and in the interest of public service, Sri Rajiv Sekhar Nath, son of so-and-so, Maibam so-and-so, division is hereby appointed as WC works as section assistant on ad hoc basis for a period of 6 months. Although vacant post were there, pension vacant post he was appointed. And
Where is the copy of the order dated 7/12/2024? Which page?
7, 12, 27, 24. Sixty-two, my lord. 62, my lord. 7, 12, 62.
So you are aggrieved by this letter? They
Yes,
are all
my lord.
junior to you?
Yes, my lord. They are junior to me, and although I was appointed in 93, the service was regularized 2015 only, and the seniority list, my lord, page 57, I will not put on my. Although I have put 33 years of service now, my. And I have been deprived of, my lord, the financial benefit allotted on, my lord, the MSc CPS scheme, my lord. That also I have been deprived of. So I am putting 33 years of service.
Yes, you are appearing.
I am for NC, your lordship. At this stage, I pray notice may be issued, your lordship, because it's a long back order, your lordship, 7/12/2023.
25 is also there, no? Is agreed by the 25.
And the read petitioner is working as what? Assistant engineer? Read
No, my
petitioner,
lord.
then
Section engineer.
section engineer or section assistant? Section engineer or section assistant?
Section
Huh?
assistant, section assistant. That is my lord, LDA. LDA, similar to LDA.
All right, heard Mrs. N. Shaken on council for the writ petitioner, the statement made in the writ petition. The petitioner herein is presently serving as section assistant under the irrigation department, Maibong, coming within the jurisdiction of Dimahasa Autonomous Council. Being aggrieved by the recommendation dated 7/12/2024 issued by the additional chief engineer, council HOD, irrigation, NCHSC, recommending, forwarding the applications of 13 numbers of regular section assistants, that is the respond numbers 6 to 18 hearing, for consideration of their case for promotion to the rank of sub-engineer grade dash capital Roman 2. The instant writ petition has been filed entirely alleging that although the private respondents are junior to the petitioner in the cadre of section assistants, yet their case has been recommended for promotion by ignoring the claim of the petitioner. Full stop. Mrs. Saikia has also prayed for an interim order of protection of interest of her client. Full stop. Ms. R.M. Dekal, learned standing counsel for Dimahasa Autonomous Council, has prayed for some time to obtain instruction in the matter. Issue notice of motion returnable on 23/7/2025. Who is appearing for whom? Who is for respond number 1? Since Ms. D.S. Nyogi, learned standing counsel for the irrigation department, has appeared and accepted notice for respond number 1. Mr. A. Solia, learned standing counsel finance, Assam, for respond number 2. And Ms. R.M. Dekar, learned standing counsel for Dimahasa
3, 4, and
Autonomous
5.
Council for respond numbers 3, 4, and 5. Service of notice upon respond numbers 1 to 5 is deemed to be complete in this case. Extra copies of writ petition, requisite in numbers be furnished to the learned department council so as to enable them to obtain instruction in the matter. Steps by registered post will be ready for service of notice upon respond numbers.
Angela, Dusty service.
What about respond number 6 to 6 to 18? It will help with you. 28 July, 28 July. 6 to 18 on the request of Mrs. Saikia. The petitioner is also granted liberty to make dusty service of notice upon the private respondent numbers 6 to 18 to be routed through the registry of this court. Heard on the prayer of interim relief, having regard to the facts and circumstances of the case, it is hereby provided that the respondents may process the application for promotion made by the private respondents, but shall keep one post of sub-engineer grade 2
There are
vacant.
3, my lord.
Huh?
Other 2 petition also there, my lord.
But shall not issue any final order of promotion till the returnable date, if not already done. Which are the other petitions?
Other petition, item 19 and supplementary 27.
These are all same.
Same. Pointed in 93 itself, my lord. Months are different.
Parties are hearing of party also same. Parties
Same,
are also same order.
same.
So you
Certain
write in the other
document
matters, so and so,
facts.
so and so. Ms. Shaikha submits that similar writ petition in the form of WPC number 3514/2024 is pending before this court. In view of the above, issue notice of motion returnable on 28/7, which is fixed on 28/7/2000. In view of the above, issue notice of motion returnable on 28/7/2023. Terms any steps by so and so, so and so, so and so, any divorce steps. List this matter along with WPC number 3514. Interim order passed in WPC number 3514 of 2025 shall operate in the present case as well. The same thing, item 27 of the code.
Obliged.
Wait, please, Your Lordship. Complement of family pension, madam. Finally, see page 38, madam. Family pension proposal pending before the respondent number 4, madam. That is Commissioner PNRD. This stage notice may be issued, madam. Pension policy.
Heard Mr. K.R. Padgiri, learned counsel for the petitioner. The writ petitioner herein is the widow of
Late Akhil Shettia.
a former Gaon Panchayat secretary who expired on 9/3/2010, aggrieved due to non-payment of family pension, which the petitioner claims to be entitled to. She has approached this court by filing the instant writ petition. Mr. S. Dattal, understanding counsel for the PNRD department, Assam, has prayed for some time to obtain instruction in the matter. NOM 6 weeks since Mr. Datta has appeared and accepted notice for respondent number
1, 4, and 6.
1, 4, and 6. Mr. A. Mr. R. Dhar, learned additional senior government advocate, Assam, for respondent numbers 2, 2 and 5. And Mr. A. Solia, learned standing counsel, finance department, Assam, for respondent numbers 3 and 7. Service of notice is deemed to be complete on the said respondents. Extra copy of the writ petition be furnished to the learned departmental counsel, requisite in numbers so as to enable them to obtain instruction. Petitioner to take steps for service of notice upon respondent number 6, the registered post will edit.
6 also, madam, represent, madam.
I will represent 1, 4, and 6.
So 1, 4, and 6. Then they tell the service is complete.
Obliged.
Please, Your Lordship. Petitioner before Your Lordship for application promotion of his service, Lordship. He is working as helper,
Take down hard. Mr. Your name, please.
SI Talukdar.
SI Talukdar and counsel for the petitioner. The writ petitioner herein is serving as Anganwadi worker under the 185 number Salibhui Kumar Ghati Anganwadi Center. Full stop. The grievance of the petitioner is that despite having rendered long years of service and being eligible under the rules to be considered for promotion, no action has been taken by the authorities to promote her to the post of Anganwadi. She is working as Anganwadi helper.
Yes, Lord.
Acha, about to help her about to Anganwadi worker. Hence this writ petition. First, Mr. R. Dhan, additional senior government advocate, Assam, prays for some time to obtain instruction in the matter. NOM 8 weeks since Mr. Dhar has appeared and accepted notice for all the respondents, no formal notice, extra copies, etc.
My lord.
Pass over.
Please, Your Lordship.
Heard Ms. S. Jad Hayat, learned counsel for the petitioner, peruse the statements made in the writ petition. the petitioner herein, while serving as a junior engineer, bracket C, bracket close, under the Town and Country Planning Department, coming with it under the jurisdiction of Department of Housing and Urban Affairs, Jorhat, was placed under suspension by order dated 6/12/2024 due to his arrest and detention in judicial custody in connection with Pulibor case number 155/2024, registered under sections 118 bracket 2 bracket close oblique 109 oblique 111 oblique 111 bracket 2 bracket close bracket small b bracket close oblique 61 of the BNS. Since he's still under suspension,
Yes.
the petitioner is still under suspension. The
Yes,
grievance of the
the
petitioner is
proceedings
that no action has been taken by the authorities for expediting the departmental proceeding, as a result of which the petitioner has been made to suffer prolonged suspension. Full stop. Issue notice of motion returnable in 4 weeks. Mr. R. Dhar, additional GA Assam, additional government advocate Assam has appeared and accept notice for all the respondents. As such, no formal notice, extra copies, etc.
Applies.
For at least another case.
But conducting council is a election under court also. The matter will be taken up.
May I please, Your Lordship? Lordship, matter pertains to non-payment of family pension, my lord. So my husband's resignation was accepted with retrospective effect, my lord. So that cannot be done, my lord. So on the last occasion, I have already submitted to.
So what is this is ready for
Judgments in-
disposal? Is it ready for disposal today?
It's ready for disposal, actually,
My-
Lordship.
How long will you take?
My lord, 10 minutes?
What about you?
Lordship, we have already filed our additional affidavit.
Okay, last item. All the other matters. Yes.
Where be your lordship? No, there are 3 issues. Lordship, you kindly have a look at this.
Hmm.
One is about providing law journals to the members of the FT manner. This letter says, there is at this stage shortage of fund possibly. And the second issue is the DDO power being taken away from the members of the FT, for which they have been facing some problem in paying the salary to the staff, etc. Well, that has been resolved. Power has been given back to them. Third issue, which is possibly very important now, and I have also personally got some calls from some of the members of the FT, that they are not getting salary for the last 1.5 months or so. And they say that it is relatable to this DDO power and all. It's not correct, my lord. After the expiry of the last term, the extension, the approval for the extension has to come from the central government. And the my instruction about 10 minutes back is from the Secretary Home, my lord, that the central government has given the approval for the extension of the members of the FT, but the file has gone to the finance department of the government of India. As soon as that comes, my lord, they will get their salary for the period after the expiry of the last term.
No, but it can't be like this.
No, it is for the central government to give us the approval.
That's
my lord.
correct, but if these are all procedural matter, how can
True.
you withhold a salary like
True.
this?
No, from our side, my lord, we have written, I am getting letters also, the reminders also we have given from
In
our.
anticipation, you have to pay them the salary. In anticipation,
My lord,
because see,
it's-
these are people are surviving
Well,
with
true, my lord.
family.
My lord, central government is all, it's not that there is some stalemate anywhere. Central government has given the approval. It has gone to the finance bill. It's a matter of 1 or 2 weeks at best, my lord. They will get it.
Difficult, Mr. Majumdar.
I'll leave it to your lordship, my lord. This is the.
We'll issue a
instruction.
direction that the Home Commissioner will ensure that the salary of current month reaches the
Well,
members.
Otherwise, yeah, otherwise it is
In
always,
anticipation of,
it is always, my lord, central government has to give the fund and they have been giving also. And its approval has already taken place. Lordship will at least give us 2 weeks time. In the meantime, possibly it will come.
no, why don't you understand? It's a question of salary of people who are surviving. This is their
True.
central government, state government, let them do whatever they want to do. But they are working.
Not that, my lord, they'll not get the salary. So matter of maybe 1 or 2 weeks. I'm told that it's coming. And certainly government has given the approval already.
By 30th of June, government will ensure that the salary reaches. We have to, whatever is required. we have to- Show this order to the central government and get it cleared.
My lord,
Show the court's order to the central government and get it cleared.
my lord,
It is
Central
24th.
Government Council will be in a better position. What
Where is the central government council? Where is Mr. Dev Chaudhary? Then we are passing some orders.
Look, this decision of the respondents not to release the salary is not uniform. Some of the treasuries they are releasing. Some of the treasuries. they release. Stop.
I'm aware of that.
Saying-
I have put these questions to them because one FT member personally talked to me and said that in some of the district possibly they are getting. It is because of the mistake on the part of the treasury that even without getting the approval, they are releasing. This is the fact.
And without salary, the staff, as the lordship says rightly
Just
said.
a minute, just a minute, just a minute. Can you please call Mr. Dev Chaudhary?
Extension or approval to central government is said in the finance of 4 years. Need the document. When section is any.
extension or to nine.
For me, India, they
Oh.
want to be part of the department. It is the problem. Until the salary. How much we share us to put. Nothing to do. Right. Want to take over it? It will not like payment to do.
Yes, Mr. Dev Chaudhary, these people are working without salary. It seems central government has held up some file. That's why the salary is, they are all family people.
Yes.
They have to get their salary.
My submission will be, my lordship may ask my learned friend to obtain the present status by Friday. Friday, let the matter be listed.
Friday is another story. What has happened?
Lordship, let take the instruction. We'll fix it up. Stay.
Day after tomorrow. Only on the point of salary.
Yes.
We'll issue a direction to issue the salary, otherwise, because it's a very sensitive matter. Ongoing people, they're working suddenly. Nobody knows why the salary is not coming. State is saying central. Then you shut down the tribunals, no? Shut down. You can't make them work and say that, sorry, some file is stuck up somewhere. What happens if the salary of the people who are making this stand is stayed by a court order? What will happen then? This kind of take unheard Mr. H.K. Daslan's amicus query appearing in this case. Also heard Mr. D. Majumdar Leonard, Senior Additional Advocate General Assam, who submits that the issues highlighted in the order dated 19/5/2025 pertaining to the issuance of pertaining to the
No, the issue number 4 is yet to resolve. The
Hmm?
issue number 4 is yet to be resolved. They are saying that there is lack of fund. Not for
pertaining
subscribing
to
journal in any of the state government offices, it would have been done
Furnishing
overnight.
two local journals to the
Six
members of
months
the
back.
foreigners tribunals with effect from May 2025 could not be implemented due to lack of budgetary provision. However, the department is examining the matter so as to address the issue without further delay. Insofar as the issues arising due to withdrawal of power of DDOs from the members of the FT are concerned, Mr. Majumdar has produced a copy of the communication dated 23/6/2025 issued by the Deputy Secretary to the Government of Assam, political bracket B bracket close department, indicating that the issue has since been resolved. Full stop. The third burning issue arising in this case is that the learned members of the foreigners tribunals have not been paid their salary since the month of May 2025. Full stop. Mr. Majumdar,
April then.
since the
April.
month of April 2025. According to Mr. Majumdar, the non-payment of salary of the learned FT members is due to non-receipt of necessary approval from the Ministry of Finance, Government of India, without which the funds cannot be utilized for the purpose. Full stop. Mr. Majumdar submits that although the Union Home Ministry has sanctioned the extension of tenure of the existing members of FTs, yet unless the Finance Department gives the necessary concurrence, the state will not be in a position to release the salary of the FT members. Full stop.
7th of May, we have again issued a reminder to the central government. I've got a copy.
The learned members of the FT are salaried people who are maintaining themselves and their family members based on the salary which they receive from the government. Therefore, if the salary of these members are withheld for no valid reason, then it is undoubtedly going to cause serious inconvenience to the members of the FT, having a potential overbearing in the performance of their duties as well. Mr. In view of the above, Mr. R.K.D. Chaudhary, learned DSGI, is granted time till Thursday, that is so-and-so, to seek instruction as to the present status of the approval of the Finance Department of Government of India, so as to facilitate appropriate order being passed by this court on the next day. This case again on so-and-so. On the next date fixed, Mr. Majumdar to also obtain instruction and place before this court as to the total financial involvement for furnishing 2 journals to the members of the FT and the manner in which the department proposes to address this issue. What is the amount? Tell us. How much harm? It will be a matter of
If it is,
5-6 lakhs.
no, it will be more than that,
Tell us what is the amount.
maybe 15-20 lakhs.
State is not able to provide
And-
that.
From it. Lordship, we just mentioned, since I have been informed, on 7th of May, we have written to the central government.
The line lower, Mr. Majumdar submits that on 7th of May 2025,
Issued a
the
reminder.
state
to
government of
central-
Assam had written to the government of India seeking necessary concurrence, which is still awaited.
Right. And Lordship is.
A copy of this order be furnished to Mr. R.K.D. Chaudhary and at DSGI.
Well-
You also want a copy?
Yes, ma'am, so that I can immediately.
Mr. Both, Mr. D. Majumdar.
Lordship will kindly fix it as 27, but 26, I got some difficulty. 27.
Tomorrow, my lord, then.
Tomorrow will be difficult. Let
Sir,
it be 27 in the morning hours, my Lordship, is
It's-
possible.
Instructions.
27.
If-
But Mr. Majumdar, there will be an order coming and we'll monitor the matter. The government has to pay their salary.
Definitely, madam.
No, it's totally unacceptable. We'll pass some orders, which will be painful.
The whole scheme is the central government.
Whatever,
provides the
whatever,
fund
let
and
them
we
make
pay.
their,
They are delaying, madam, we have,
no, you
Cent-
make arrangements.
central government.
You make arrangements. You know, in principle, sanction is granted. So you tell us whether the approval is granted or not.
Approval, I'm told, is already there. Only
Then what is the
from the
problem?
finance department, it has to come, nothing else. Central government has, in principle, given the approval.
Then what is the problem? Why are you
I-
withholding the salary?
And my lord, the last extension expired on 22nd of May. After that, period after that is creating difficulty, not for the month
No,
of
my
April.
lord. The salary has been stopped in the month of April.
No, there is-
Term and on 22nd of May. They should have initiated the process at least 2 months back. They are waiting.
Why don't you close down the FTs if you are not interested?
I'll find out what is the,
Either have it running properly or close it down.
mine.
And apart from that, there was a,
So, Mr. Majumdar, problem is this monitoring bench has been constituted under order of the Supreme Court
Mine,
to ensure that
absolutely.
the tribunals function. So we'll not hesitate in passing some
Yes.
order.
apart from that, so far as
I'll
books-
communicate all
books-
this, my lord,
So
the
journalist.
anxiety of the court, madam.
Journal is concerned, in the month of May, Lordship issued a direction. Issued a mandamus, but they are not complying. This is not an adversarial litigation, but there should be some respect to the orders passed by this court. For 15 lakhs
We'll
rupees, they are
we'll
saying.
deal with it. We'll deal.
Much of it. Hello.
The 22. Covered review your lordship. Covered by lordship order, the review.
These are all review petitions.
Consent order,
We dispose of all.
22 to
And
26.
the name is RM Deka, change the file number. You know, these are similar orders. Yes, disposed of.
Filing number 3.
22 to 26 disposed of. None appears for the petitioner even on second call. Matter stands passed over for a week.
Item 20.
Please, Lordship.
Lordship, petitioner's husband was temporarily appointed as peon on 25/8/1988. Thereafter,
1 minute, 1 minute.
my lord,
When was he appointed?
his service was regularized with effect from
I have asked when was he appointed? You are answering me service.
25/8/1988, my lord.
As peon.
As peon, temporarily appointed, my lord. Thereafter, on 8/6/1990, his service was regularized with effect from 1/4/1990.
8/4.
1/4/1990.
Service was regularized on 8/6.
8/6/1990, my lord. Thereafter, he
Yes.
was promoted as field assistant on 11/09/1996. On 5/6/2006, he submitted a resignation letter. As that resignation was not acted upon by the respondent authority, therefore, on 21/07/2014, he made another application referring that resignation letter. On 3/2/2015, petitioner's husband died, my lord. And finally, on 26/11/2015, the impugned order was issued accepting the resignation letter with retrospective effect after the death of the petitioner's husband. So my humble submission, my lord,
Where is that letter, 26/11/2015?
my lord will find at page 33. And on the same day itself, my lord, on the next page, my lord will find at page 34. His leave was granted till 5/6/2006. His leave was approved. And leave from 1/5/2004 to 8/1/2005. Commuted leave from 9/1/2005 to 17/6/2005. Then extraordinary leave from 18/6/2005 to 5/6/2006. So thereafter, they have retrospectively accepted my resignation from 6/6/2006.
Yes.
So it seems that, my lord, he was on authorized leave till 5/6/2006. And my only submission here is that resignation cannot be accepted with retrospective effect even after the death of the incumbent, my lord. And there are judgments of this honorable High Court. Already I have referred in the last occasion, my lord.
Which judgment?
Assam Administrative, Amalendo Sen, Assam versus Assam Administrative Tribunal. My lord will find at para 5. Oh, sorry, yes, 5. Oh, sorry, I'm extremely sorry. My lord, I'm sorry. Power Finance Corporation Limited, my lord, versus Pramod Kumar. Page 7, para 7, my lord. It is now well settled legal position that unless the employee is relieved of the duty after acceptance of the offer of voluntary retirement or resignation, During the relationship of the employee and the employer does not come to an end. Since the order of accepting the voluntary retirement was a conditional one, the conditions ought to have been complied with before the conditions could be complied with. The appellant withdrew the scheme. Consequently, the order accepting voluntary retirement did not become effective. Thereby, no vested right has been created in favor of the respondent. One another the- it does not affect the- It is yet for issue.
But this is for voluntary retirement.
No, sorry, my lord. Yes. This one, Nalini, Assam Transport Corporation versus Nalini Ranjan Aditya, my lord. This para, my lord will get at para 13. I'm sorry, my lord. Assam State Transport Corporation versus Nalini Ranjan Aditya. Para 13 is relevant here, my lord. The next question is regarding the effect of the acceptance of the resignation letter. The settled position of law is that a resignation becomes effective from the date of its acceptance. So in the case in hand, accepting resignation with retrospective effect is a clear violation of the legal provision, and accordingly, I hold that the resignation became effective from 29/12/1975. That is the date on which it was accepted. Therefore, till that the relationship of the master and servant between the employed person and the corporation continued, and the employed person is entitled to get 50% of the wages for the unpaid period till that date. So the petitioner's husband died in harness. As if your lordship applies this ratio, my lord, that cannot be accepted with retrospective effect, my lord. Petitioner husband died on 3/2/2015. And
So what happens for the period between 5/6/2006 and 3/2/2015?
That period, my lord, he was on leave basically because he was ill during that period, my lord. He was absent, my lord.
Mr. Deka, unless you give an answer, it will not be possible for me to write a judgment. Because it's all right.
He might be absent, my lord.
But if the resignation is not accepted,
Yes.
then they may dismiss him from service also, take away all benefits. So you have to address the court substantively on that.
My lord, no.
Just a minute,
My-
listen to this, it will help you.
My-
If not today, some other day. I agree with you that they could not have accepted the resignation of a dead person. So let us say this 26/11/2015 is set aside.
My lord.
But how does it help the petitioner's cause?
My lord, Mayor, if suppose he was absent during that period when that cannot take away his rights for the pension, my lord.
Can't say. Because if you are unauthorizedly absent, then they may initiate a DP.
My lord.
Listen, they may initiate a DP.
My lord.
In the DP, they may dismiss him from service, in which event everything will go away.
My lord, they have not initiated any DP during his lifetime, my lord. He died already. No notice was issued to him why he was absent, my lord, during that period.
But you were absent. Your client's husband did not attend duty.
My lord, he might be absent, my lord. But that doesn't forfeit his service benefits, my lord, the pensionary benefits.
Show
My
me
lord.
the judgment. Show me the authority on that.
My lord, basically, if the unauthorized leave.
See, Mr. Deka,
Coming from
you are
the-
asking for a judgment from the High Court,
My lord,
recognizing the right of the petitioner as the widow to receive
my lord,
pension, right? So, setting aside the order accepting resignation is only a small part of that.
my lord.
If that is interfered, that doesn't mean you get the right of pension. You still have a long way to go to show that this is how the legal fictions will kick in one after the other. So that you have to address argument on that. This is accepted.
My lord.
Now you address argument.
My lord, in
Let
that
us assume that 26/11/2015 is declared as illegal.
yes,
Then you are back to the position of 5/6/2006
my lord.
because till then they have regularized the period of
But
absence.
till that, my qualifying service was there, my lord, for pensionary benefits.
No, but what happens to the period after that? that the court will have to say it. Otherwise, the matter will go back to them to again reconsider application and take appropriate decision.
My lord,
If you want that order, I can pass.
my lord, in that case, if your lordship will look at pay, rule 64 of Assam Services Pension Rules, my lord.
Rule 64.
Yes, ma'am. 62 said about resignation and dismissal, my lord.
Hmm.
And 64 says, my lord, regarding the interruption period, my lord. So my lord, got it. An interruption in the service of an officer entails forfeiture of his past service, except in the following cases. My lord, authorized leave of absence, number 1. Number 2, my lord, unauthorized absence in continuation of authorized leave of absence, so long as the office of the absentee is not substantively filled. If his office is substantively filled, the past service of the absentee is forfeited. So his office was not substantively filled, my lord. His post was not substantively filled.
All right, we'll send it back. We'll set aside the order of acceptance of resignation and hold that his resignation was never accepted during his lifetime. So let the pension claim be decided in accordance with law. This court cannot take a decision on all these things. Whether he is substantively filled up or not filled up.
My lord, as it seems, my lord, till 5/6/2006, my lord, he was on authorized leave, my lord. Even if thereafter he was on unauthorized leave, that cannot be considered as an interruption, my lord. As per 64, my lord.
We can't decide this. Let them first give their opinion and take a decision on that. At the moment, the only relief that you can get is that this order of.
There is no whisper in their affidavit, my lord, regarding that, my lord.
All right. You argue. You complete your argument.
And my lord, in that.
Yes. Yes.
My lord. If your lordship ever look at their affidavit, my lord, there is no whisper. They have only said in their para 8.
Yes.
As regards the statements made in paragraph 6 of the writ petition, the deponent begs to submit that as per record, the petitioner's husband died on 3/2/2015. The petitioner's husband, while serving in the directorate as FS Statistics, was regularly irregular and remained absent in office duty with effect from 1/5/2006 without prior information to his superior till the date of his death on 3/2/2015. Therefore, application for resignation submitted by the petitioner's husband, Biren Daka, was accepted with retrospective effect from 6/6/2006. The irregular period with effect from so-and-so was regularized by granting earned leave, commuted leave, and extraordinary leave as per applicable rules. So that they have granted that leave period till 5/6/2006.
So therefore, pursuant to his appointment in 1988, he was legitimately in service till 5/6/2006. Let's take that position.
Yes.
Even if
Lordship,
that is the case, then also he would be entitled to pension under the rules.
Under the rules.
Yes.
Right.
Lordship.
You
If
have
it
not
is-
argued that. Take your seat. You have not argued. You are not arguing on anything which is relevant. You are again and again on.
Lordship,
I am saying that you are not disputing the fact that he was initially appointed temporarily on 5/8/25/1988.
Eight.
Thereafter, he was regularized in 1990.
98.
since 1990 to 5/6/2006, he was validly in service, right?
That is,
You
after
have regularized his period.
we have regularized his
Yes.
period, but
So
he
till
was-
5/6/2006, he was an
we have
employee.
regularized, but he was continuously absent from 1/5/2004 to 5/6/2006, which we have considered after we have accepted his resignation. At that
Right.
time,
So
766
at least let us say that we maintain whatever is the position.
Lordship.
Why are you not giving family pension to the wife? He has not argued this, but I am asking you. That is the plea
Lordship,
here.
yes.
Let us grant everything. Because setting aside the acceptance of resignation is going to complicate things further.
Lordship.
We'll maintain the resignation. Everything is maintained. But he was in service in an authorized manner till 5/6/2006.
Lordship.
So that means he has at least spent 16 years of service,
Service,
regular employee,
yes.
and another 18 years.
2090 to 20,
Yes.
from 2090 to 2026, 2006. Yes, Lordship, we have
So
already.
why would she not be entitled to family pension?
No, Lordship, actually, we have also considered their application for compassionate appointment also. His wife's compassionate appointment, it was also considered, Lordship.
No, but it was given.
No, Lordship, due to vacancy, paucity of vacancy, it was not given, Lordship. But if in that case, we will consider his pension, family pension at least, as his 16 years of service. Considering his 16 years of service.
None of you are ready for a final order today, huh? You are also not ready. What is the solution to the problem?
My only submission is that
Your submission is think of a date when the matter will be listed again. Come prepared. These arguments are of no use. Resignation, set aside. So set aside, fine, what happens then? You are not going to get family pension. How will you get family? You have to tell the court that this is my right, this is how it flows.
so they
What
are,
is the flow of your argument?
but till 5/6/2006, qualifying service was there, my lord, for pensionary benefits.
What is the qualifying service? How many years?
It's 10 years, my lord.
Where is it? Which provision?
My lord will find
Hmm.
at para 31, rule 31
Rule
of Assam
31.
Service Pension Rule.
Yes.
So in the down below, there is a office memorandum, my lord.
Hmm. Is there anything which says minimum this many years of service will be required for
Yes,
getting?
here, my lord, office memorandum, the next second para, my lord, further the government employees rendering less than 10 years of service are not eligible for pension. Means the person who are above 10 years of service is eligible for pension, my lord.
But this is about provincial as panchayat employees. What are you saying, Mr. Dekar?
Lord, it's,
It
though
is not to be treated as precedent. That's what they're saying. It is for panchayat.
that office memorandum, my lord.
See, I don't have time now to do my research and write a judgment. So you have missed out. Can't help it. Come prepared. You are not clear with your matter. And since they are also not forthcoming with any clarity.
Lordship, that is rule 108 of pension.
108
Huh?
of pension.
108 of pension rule.
108A, Lordship.
No, but where is the rule which says if you have rendered minimum such and such years of service, then the employee will be entitled to pension? Where is that rule?
10 years.
10 years.
Where is that rule? Because you say so, or there is some rule. No, it is not 10 years. It is 9.5 years. Show me where is 10 years. Where does it say it is 10 years, Mr. Dekar?
My lord.
After vacation, I'm prepared. This was an open and shut case if you were prepared. I was about to dictate the judgment. There is something, but I cannot do research now. It's not possible for me. Every time I have to do my own research to write a judgment. Where is the provision of the rule which says how many years of minimum service is required to be entitled to pension? That all of you don't know. No idea. If there is clarity on that, then maybe we'll not comment on the acceptance of resignation. But since you have sanctioned his leave till 5/6/2006, on that day he is retired voluntarily. So he is retired on 5/6/2006. So that means he has rendered more than 16 years of service. Then why have you not given the sanctioned the pension to the wife, family pension? Why? Have you stated in the affidavit?
If they are not denying the family pension also, they are only, all the record, the information they have given is that they have only considered their appointment for compassion, her appointment for compassionate appointment also, but not about the family pension. I have to clear that part.
No, we have been denied pension, my lord. Family.
Take that. Heard Mr. I'm disposing it off. You submit a fresh representation. Heard Mr. B.M. Dekar, learned counsel for the writ petitioner, also heard Ms. M. Photoki, learned standing counsel for the Department of Animal Husbandry and Veterinary, Assam, Guwahati, appearing for the respond numbers 1, 2, 3, 4,
6.
1, 2, 3, and 4. Mr. D. Bora, learned G. Assam, appearing for respond number 5. And Mr. R.K. Talukdar, learned standing counsel for the office of AG Assam for respond number 6. None has appeared for the respond number 7. None has appeared for the respond number 6. Although the name of the learned standing counsel, Finance Department, Assam, is duly reflected in the cause list. Full stop. The writ petitioner herein is the widow of late Biren Dekar, who was an employee under the Animal Husbandry and Veterinary Department. Late Biren Dekar died on 03/02/2015. The grievance of the petitioner is that although her husband was entitled to receive pension, yet no family pension has been sanctioned to the petitioner till date. Full stop. It appears that the petitioner is also aggrieved due to non-payment of earlier salary and other pensionary dues payable under the rules on account of the service rendered by her deceased husband. Full stop. The facts of the case in a nutshell, as appearing from the materials on record, are that the late husband of the petitioner, the deceased husband of the petitioner, late Biren Deka, was initially appointed as a peon in the establishment of Joint Director of Animal Husbandry and Veterinary, Guwahati, wide order number 166 dated 25/8/1988 in the scale of pay of rupees 370 to 490 per month with effect from 1/7/1988. Pursuant to the order dated 25/8/1988, Biren Deka joined service as peon. By the order dated 9/3/1989, the earlier order is so against a leave vacancy. 25/8/1988 will be against a leave vacancy. Full stop. While Biren Deka was discharging his service by order dated 9/3/1989, he was temporarily appointed as a peon in the vacant post of peon, which had occurred due to demise of late Aurobindo Deka. Full stop. Full stop. While rendering his services as a peon, as a temporary appointee, the service of the petitioner's husband where is the order of regularization?
My lord, at page 23, my lord.
Page 23.
Yes.
The service of Biren Deka was regularized in the grade 4 post with effect from 1/4/1990 in the scale of pay of rupees 370-490 per month plus other allowances as admissible under the rules by issuing order number 267 dated 08/06/1990. Full stop. Pursuant to his regularization in service, the husband of the petitioner continued to work in the grade 4 post. However, it appears that due to some health issues, the petitioner, the husband of the petitioner was irregular in attending his duty with effect from 01/05/2004. Full stop. On 5/6/2006, Biren Deka submitted his resignation before the authorities as he was unable to attend duty any further. However, no action was taken on such resignation submitted by the petitioner. Situated thus, the petitioner's husband, situated thus, on 21/7/2014. Where is 21/7/2014 application?
My lord, page 31.
The deceased husband of the petitioner had addressed an application to the Director of Animal Husbandry and Veterinary Department requesting the authorities to take an early decision on the resignation submitted by him. First up, even thereafter, now it appears that even thereafter, no action was taken in the matter by the authorities. In the meantime, Biren Deka expired on 03/02/2015. It was only after the death of Biren Deka that on 26/11/2015, the authorities had issued a communication conveying the decision to accept the resignation of the petitioner's husband with retrospective effect from 06/06/2006. Full stop. Further, it was also intimated that Biren Deka was granted earned leave from 01/05/2004 to 08/01/2005 for 253 days on medical ground number 2. This will be number 1, Roman 1, this is number 2. Commuted leave from 09/01/2005 to 17/6/2005 for 160 days on medical ground, and number 3, extraordinary leave without pay from 18/6/2005 to 5/6/2006 for 353 days. Full stop. From the above communication, what clearly appears on the face of the record that the authorities had accepted the resignation of the petitioner with effect from 5/6/2006, and as regards his period of absence from 1/5/2004 to 5/6/2006, such period has been regularized by adjusting the same against the leave applicable in case of the petitioner. Full stop. Notwithstanding the same, the request made by the writ petitioner as widow of Biren Deka for grant of family pension has not been considered by the authorities. Full stop. Next, addressing arguments before this court, Mr. Deka, learned counsel for the petitioner, has vociferously argued that acceptance of resignation with retrospective effect, that too after the demise of Biren Deka, was impermissible in the eyes of law. First up, in support of his above argument, Mr. Deka has placed reliance on the decision of this court rendered in the case of Assam State Transport Corporation versus Nalini Ranjan Aditya, reported in 1992, 1 GLR 383, to submit that an order of retrospective acceptance of resignation is invalid in the eyes of law. Full stop. Responding to the said submission, Ms. Kotoki has argued that although there was some delay in communicating the acceptance of the resignation, yet since the late husband, the deceased husband of the petitioner is no longer alive, such delay would be inconsequential in the facts and circumstances of the case. Full stop. After hearing the arguments of learned counsel for both the sides, this court is also opinion that regardless of whether the acceptance of the resignation submitted by Biren Deka with retrospective effect that too after his demise, was valid in the eyes of law or not. The central issue that would arise for consideration of this court in the present proceeding is as to whether the writ petitioner herein can maintain a claim for grant of family pension and other retirement dues on account of her husband by filing the writ petition. First up, the answer to the said question in the opinion of this case must be in the affirmative. Full stop. This court has noticed that the writ petitioner who was initially temporarily appointed, the husband of the writ petitioner who was initially temporarily appointed as a peon on 25/8/1988 was in service till 5/6/2006. Therefore, Biren Deka had admittedly and evidently served under the government of Assam in a pensionable post for a period spanning more than 18 years. Full stop. If that be so, there is nothing to indicate as to why it should be held that the deceased government servant was not entitled to the benefit of pension as admissible under the Assam pension rules of 1996. Full stop. Rather, it appears from the reading of various provisions of the Assam pension rules, more particularly Rule 31 and 108 of the rules, that the petitioner would have been entitled to pension and obligor at least proportional pension for the period of service rendered by him till 5/6/2006. If that be so, not only would the petitioner be entitled to the arrear of pension as applicable with effect from 5/6/2006 till the date of his demise, but even his widow, that is the writ petitioner herein, would also be entitled to receive family pension at the admissible rate. That apart, arrear salary oblique dues, if any, payable on account of Biren Deka would also be receivable by his widow if the same is applicable, if the same is payable under the relevant rules. Full stop. There is no clarity in the affidavit filed by the department as to why such dues of the petitioner has not been released till today. Full stop. In view of the above, without commenting on the validity of the order dated 26/11/2015, this court is of the opinion that the right of the petitioner as widow of Biren Deka has crystallized as on 5/6/2006 by virtue of the order dated 26/11/2015. Full stop. Therefore, her claim to receive pension, stroke family arrear pension, stroke family pension, and other retirement dues payable on account of late Biren Deka as on 5/6/2006 cannot be denied to her. For the reasons stated herein above, this writ petition stands disposed of with a direction upon the respondents to consider the claim of the petitioner for release of family pension, stroke arrear pension, stroke arrear salary, if any, arrear salary payable to the husband of the petitioner in the right of the observations made herein above. Full stop. Facilitating the above, the writ petitioner to submit a fresh representation by enclosing a certified copy of this order before the competent authority within 6 weeks from today, ventilating her grievance. If such representation is submitted within 6 weeks from today, the same shall be considered in accordance with law and shall be disposed of by a speaking order within 8 weeks thereafter. Full stop. Whatever be the outcome of the process, the same be intimated to the petitioner in writing. If the petitioner continues to remain aggrieved in the matter even thereafter, it will be open for her to approach this court once again by filing fresh writ petition. Full stop. That's all. If you give her the pension,
Lordship.
we'll impose cost and interest if you don't give it. Full stop. Since the court is directing the department to consider the prayer of the petitioner in the light of the observations made herein above, at this stage, this court is of the opinion that there is no scope for granting any interest component to the petitioner, which aspect of the matter is kept open and will be considered at an appropriate stage as and when the occasion arises. The petition stands disposed. There will be no order as to cost.
Much obliged.
You should come prepared.
My lord.
You are not prepared. Did you understand what you have done?
Yes, my
You are stuck up on resignation. What difference does it make? Your client has to get something in hand. You must know every time you come to the court, what are you asking the court to do and how does it help the cause of your client? You have to give a complete solution to the problem. Otherwise, it's incomplete advocacy. Yes.
Much obliged.